Number 26285 FT, appearance of counsel.
Nate Carnes on behalf of the people.
Thank you, Your Honor. Taylor Ann Vento on behalf of Mr. Spears. I'm filling in for Attorney Harrison today. He's in trial in circuit court. Mr. Spears is joining me at counsel table.
Mr. Spears, Mr. Harrison is your appointed attorney, but he has a conflict today. Are you all right with Ms. Firavento filling in for him?
Yes, Your Honor.
All right. Counsel, we're here for a probable cause conference. It does not look like there's a resolution because I have a signed bind over in the file, but I understand we want to address bond. Is that accurate?
That is correct, Your Honor.
Any objection to that, Mr. Collins?
No, Your Honor.
Ms. Firavento?
Thank you, Your Honor. Currently, Mr. Spears' bond is set at $25,000 cash. We would respect the request that that be reduced, or at the very least, that it be allowed bondsman or 10% on that file. As the court is aware, MCR 6.106C states that release on personal recognizance is effectively the default, unless for some reason the court thinks that some additional terms are necessary to ensure public safety or to ensure attendance of the defendant at future court proceedings. As to the first issue of public safety, he has minimal criminal history and his practice score was 3. As to the issue of attendance, well, it's my understanding he does have some flee and elude. It's my understanding he was on probation at HIDA in the past and was successful. In consideration of those things, he would have high likelihood of attending future proceedings through his prior actions and through his low minimal criminal histories. So that would still bring us pretty well into the dominion of 6.106C. Now, if the court disagrees, in the alternative, looking then to 6.106 subsection D, which deals with the conditions that a court may impose on someone when they find that they don't fall into subsection C. We would argue that $25,000 cash, again, given the minimal criminal history.
So it's a cash surety.
It's marked as cash on the order we have, Your Honor.
If it is, that's a mistake because it should have been cash surety.
I think it's cash / cash surety on the ATR.
Let me look at the order here. Yeah, it's marked cash surety.
Thank you, Your Honor. But still, $25,000, even cash surety, even at a 10%, is still quite excessive given the overall conditions here, given the minimal criminal history and the low practice score. If I can cite to, we are getting into the territory of excessive bail for someone of Mr. Spears' means. And as is stated in MCL 7. And as is stated in MCL 7.65.6, the second sentence there, the amount of bail shall not be excessive. We would respect the request again, a further reduction, a lower amount, something that is in the realm of affordable for Mr. Spears, because where it is right now, it is just outside of the realm of affordable for him. Thank you.
What do you score him at?
The praxis that we had in the file.
No, I'm talking about the guidelines.
On the guidelines.
Yeah.
Unfortunately, I have not read the scored the guidelines, Your Honor. I can see what Mr. Harrison has in the file, though. I know he is run now.
Okay.
One moment. Mr. Harrison scored him at 0 to 9 on the UDAA, which would then, I think, bring in arguments under MCR 6.106 subsection F subsection 3 that MCR 6.106C shouldn't be used to essentially sanction pretrial detention.
All right. Mr. Carnes?
Thank you, Your Honor. I would point the court's attention to the allegations here, which do suggest that the defendant would be a flight risk and that he poses a danger to the public. The victim had his car running at 4:45 in the morning be common in the winter here to warm up your vehicle before you drive to work. Well, he gets out there and his car's gone. He calls the police. The police are looking for this stolen vehicle. They see it. The vehicle crashes while running away from the police. The police follow footprints and see defendant climbing a fence. This is the only set of footprints around. They arrest the defendant and he's drunk. PB. I'm sorry, the intoxilizer was 0.13, 0.12. I think the defendant is a danger to the public, both with property crimes, stealing a vehicle, and then drunk driving is clearly a risk to the public. And additionally, I think stealing a car shows that he's a flight risk, especially combined with his history of flee and elude conviction. I think bond is appropriate where it's currently set. I'd ask the court to keep it there. Thank you.
Mr. Carnes, I noticed there's not a resist and obstruct charge or a flee charge. So as you said, he was running from the police. Had they turned on their emergency lights to try to stop him?
I don't think they turned on the emergency lights. I think he crashed. And then as he was climbing the fence, the police told him to stop and he stopped. So I guess it's, he did leave the scene of the accident before they arrived. We probably should have charged that misdemeanor, but
Before police arrived, he'd left the scene?
yes.
But it couldn't have been. So you said they followed his footprints?
They followed his footprints and they encountered him on the fence. And then at that point, he was compliant.
All right. Ms. Fiervento, any rebuttal?
Thank you, Your Honor. I would just emphasize again, conditions can assure the public safety here. Random alcohol testing is already ordered if bond was posted, and my client has no issue with that. He would also have no issue with tether or other conditions to assure public safety short of a high monetary bond. Thank you.
Mr. Carnes, am I correct? I seem to remember from the arraignment that the vehicle that he allegedly took was totaled. Is that accurate?
Yes, Your Honor, there was significant damage. The victim was distraught, to say the least.
What did he hit? Allegedly, sorry.
Says the vehicle was crashed in the front yard of an address on South Mitchell Street. Doesn't say what he hit.
And you said a .1212?
0.12 and a 0.13 on the intoxilizer.
All right, looking at the defendant's past, there was a malicious destruction of property less than 200 in 22. There was a flee third in 22 that was handled pursuant to HIDA, as Ms. Fiervento mentioned. The court does have concerns about the defendant's being a flight, given his actions in this case, allegedly leaving the scene of an accident after having stolen a vehicle. However, when he was instructed to stop, it's reported that he did stop. So I will reduce the bond. I'm going to set a $10,000 cash surety bond with the conditions of no alcohol and random testings. Given the praxis, I do have some concerns regarding controlled substances. So no illegal drugs, no recreational marijuana. Be subject to random testing as well. Or to enroll in community correction services. Anything else, counsel?
No, Your Honor, thank you.
No, Your Honor.
All right. I will sign the bind over. Thank you.
Thank you.